Are there any opening statements from either side?
No, the state will waive opening.
Waive opening.
All right, state, you may call your first witness.
Preliminarily, the state, Your Honor, the state would like to offer and admit.
The stakes are set right out the gate. The prosecution moves quickly, asking the judge to take judicial notice of prior testimony, essentially fast-tracking the process by skipping the need to reintroduce it from scratch. It's efficient, yes, but risky. Because if any part of that previous testimony has cracks, the defense will be ready to pounce.
All testimony and evidence that was heard in the guilt innocence basic trial.
I believe the judge can take judicial notice of those things.
All right, and the court will take judicial notice of the prior testimony, of course, with the defense's objections as well from the prior testimony.
And all the exhibits as well.
Yes.
Okay, then the state would also offer State's Exhibit A into evidence, pending any objection from the defense counsel pursuant to Rule 902.
I object on lack of proper foundation and link to defendant and hearsay.
Yes. All right, the objections as it relates to hearsay, those will be overruled. It appears to the court that State's Exhibit A is a self-authenticating document. However, with regards to whether or not this is...
Here's where it gets spicy. The document is self-authenticating, meaning it doesn't need a witness to verify its legitimacy. But the judge isn't buying it. There's no clear tie to this defendant. Without that crucial link, it's just a piece of paper. The defense scores a small but meaningful win.
Connected to this defendant, then that objection will be sustained.
And Your Honor, if the state could respond, the state would respond that that goes to weight, not necessarily admissibility. It is a self-authenticating document.
No, I'm overruling her objection as far as that this document is not what it purports to be. It is self-authenticating. But what the part of her objection that I'm sustaining is that State's Exhibit A has not been tied to this defendant.
Well, yes, Your Honor, I understand that.
So foundation will have to be laid to somehow tie this document to this defendant.
Please tell the court what your area of expertise is.
I'm a fingerprint examiner for the Bexar County Sheriff's Office.
And do you have any, you possess any?
Yes, I have a certification in classifying fingerprints as well as identification of fingerprints.
Please explain what those documents are.
So we go through a rigorous course to understand the characteristics of fingerprints as well as on-site training to understand fingerprints.
Let's talk about fingerprints specifically. What is it?
A fingerprint is a print that consists of 12 characteristics that can identify an individual.
Have you ever found?
Let's break it down. It takes 12 unique fingerprint characteristics to confirm a match, like a biometric signature that's entirely your own. Not even identical twins share the same print patterns. So when the state claims they've got those prints, the jury isn't just hearing evidence. They're about to hear something they can't unhear.
Have the same set of fingerprints?
No, not to my knowledge.
Can you please explain how you do a fingerprint comparison?
So when we first get the fingerprints, we do look for, like I said, the 12 ridge counts. And we will compare to see if the individual that we do have in custody is the same person that is on the fingerprint itself. And then we do our Henry classification that classifies the specific characteristics of the fingerprint.
Now, if that is your way of doing it, is that the standard way?
That's the standard way.
That's the what way?
The standard.
Can you take the witness on board, Ariana?
Yes.
Okay. I may be a little confused. This Exhibit B, when were those prints taken?
These were taken today.
And so when you were saying that those prints were taken by me, is that the one you were referring to?
Correct.
Okay. And so there's some other prints in the packet, right?
Correct. They're on the back of it.
Okay. But you were not saying you took those prints, right?
No, I didn't.
Okay. So you don't know my client, right?
No.
So you can say that the prints match, and you can say that you took the prints of my client today, correct?
Correct.
But you weren't present when the prints were taken originally, right?
No, ma'am.
And so you can't say didn't witness that or who the person was who gave the prints.
Correct.
Right. I would object to relevance and lack of affirmative link to my client.
All right. And so is the testimony,
I'm sorry.
was it established who these prints and States Exhibit B were taken from?
I'm sorry, Judge?
Was it established who the prints were taken from in States Exhibit B?
Yes.
She did test-
What individual? Do you want to, yes.
You testified that you took the fingerprint States Exhibit B today, correct?
Correct.
You see the person in the photo that you took those fingerprints from?
Yes, sir.
Could you please point to that person, identify him by an article of photos?
Will be the gentleman in the red.
You represent the record reflect that this is identified the person that you took it.
Boom. The witness points directly at the defendant. Gentleman in the red. That visual ID ties the prints collected today straight to the accused, tightening the case against him. In that moment, the defense's claims of uncertainty start to unravel, and despite their objections, the judge admits the exhibits into evidence.
Fingerprints from States Exhibit B.
All right. Defense, any objection with regards to States Exhibit A and B?
Every urge the same objections, Your Honor. She has no knowledge of the person who gave the original prints.
All right. Those objections will be overruled. States Exhibit A and B are admitted over defense counsel's objection. State, any other witnesses?
No, Your Honor, the state will rest.
Defense, any witnesses?
No, Your Honor.
Defense, do you rest?
Yes.
State, do you close?
Yes, Your Honor.
Defense, do you close?
Yes.
All right. As previously stated, the court is finding the enhancements true, and the court is finding the enhancements true that were read into the record for count 1, and also the enhancements true that were read into the record for count 2. The court will hear argument with regards to sentencing. Mr. Nicholson, you are not eligible for probation from the court. All right.
Yes, Your Honor. The state would like the court to consider States Exhibits 39 and 40, which was entered in the guilt phase of trial. That's going to be the judgment from Austin for the conviction of assault enhanced. And additionally, the fingerprint part that was linked to that judgment in the guilt phase of trial. Your Honor, this defendant does have a very lengthy and violent criminal history. In 1996, he was sentenced to 20 years for aggravated robbery. That's going to be cause number ending 60 that we entered in today. He was additionally sentenced for burglary of a habitation on that same day. That's going to be cause number ending in 59 that was entered into evidence today as part of States Exhibit B. States Exhibit A. Your Honor, he was sentenced in 1996 to 20 years in the Texas Department of Corrections for those crimes. When he was released, it was not very much longer until 2013 that he committed the offense in States Exhibit 39 for assault enhanced, where he was convicted and sentenced to 6 years. So in 2019, after their 5 years are done, it took him only 3 years to commit this offense, this violent offense, where he shot at an unarmed Uber.
He shot at an unarmed Uber driver. Why? Simply for picking up his stepdaughter. The fact that no one was injured wasn't due to strategy or restraint. It was sheer luck. So the real question becomes, how close did this come to turning into a tragedy? And does that terrifying possibility warrant 40 years behind bars?
Driver who just happened to be picking up his stepdaughter so that she could go to work. Thankfully, nobody was hurt in this offense, but that's just luck, Your Honor. The capacity for this defendant to hurt people in this community and to hurt his family is shown by the criminal history, and the state is asking that the court sentence the defendant to no less than 40 years on count 1 and no less than 20 years on count 2.
Defense?
Thank you, Judge. I know that we've heard about his criminal history and the seriousness of it. I did want to offer some context to that, which starts with the fact that the first offense that for which he did the 20 years, he was actually age 16 when that happened. And he was certified as an adult and sentenced, and he ended up doing most of the time. He really lost so many of his formative years at doing that time, right? And then he gets released and is having trouble and has continued to have trouble adjusting. And the second case, the family violence assault case, he pled to and he acknowledges, and I'm not saying he doesn't acknowledge the first case, but he does ask, and we do ask the judge to consider how young he was at that time. I have had contact with two of his family members, siblings, who were not able to be here today. One was a Mr. Paxton, and another is a sister, Samantha Romborg. And if I may, they both relate to me the chaotic and troubled childhood that they had, and how, in spite of what you see here today, that Mr. Nicholson was actually a loving and caring brother.
I'm sorry. Do you want those witnesses here?
No, I think we discussed it,
Okay.
that their father was a drug addict, and all the children in the family suffered tremendously, and that Dominic felt an enormous responsibility to try to provide for his siblings, which
Now we see a different side. Dominic's childhood was filled with trauma, addiction, and burdens no teenager should ever have to carry. The defense shifts the narrative, portraying him not as a villain, but as a damaged protector shaped by a harsh reality. Yet, this raises a powerful dilemma. Can a tragic past excuse present actions, or does accountability still hold firm?
For present
led him
violence?
to
What
make
would you
very
do if you wore the
poor
robe?
choices to accomplish that goal, but that his actual motivation, and led him down a criminal path, which I guess partly was role modeled by his father, but also his sense of duty and obligation to his siblings, and having very limited ability and resources to provide for them in his overwhelming sense that he should try to provide for them, really hindered his thinking, and obviously has made extremely poor judgments. I know we stand here today, the jury heard the evidence and returned their verdict, but Mr. Nicholson believes that he can return to society and be rehabilitated. This has been a long, revolving door in his life that he is very tired of. And so we would ask the court to please sentence him at the minimum.
All right. State any final closing argument?
Your Honor, the state does appreciate that Mr. Nicholson was young when he committed the first offenses. However, I think that just speaks to his values as prior life. And although the hopes for change are there, according to defense counsel, his actions speak louder than his words. And the court would like, the state would like the court to consider those actions, the harm that he could have caused on October 25th, 2022, and the harm that he has caused throughout his life.
All right. Is there anything you would like to say?
Yes, ma'am.
Here's the thing. If you want to say something, I'll take you under oath and the state will be allowed to question you. I mean, if you want to discuss it more with your attorney.
My life to be over like this, not being able to say anything, but I won't say
No,
anything.
I mean, we can go off the record. Here's the thing. Once you decide to testify, and I think your defense counsel will tell you there are certain appellate issues that may or may not be waived. So it's completely up to you. If you want me to hear what you have to say, I will hear it. What I can tell you with regards to my clients, sometimes they will want to speak, and I would tell them, your family has already told your story. Are you going to say something different than what your family has said? So the state was very generous in allowing your counsel to make a proffer to the court about your childhood. So, but if you would like to say something, it's only fair, because I want to be fair to both sides. You don't get to just say something and then that's it. What will end up happening is I will swear you in. You'll be under oath. And if you just want to speak generally to me, you can speak generally. I'm not going to sustain any objections for narrative, because sometimes people just want to tell me what their thoughts are and I will listen to them. But that being said, whatever your thoughts are that you want to make sure that I know about, then the state will be allowed to cross-examine. So if that's what you want to do, then we can do that.
I've seen it. I hope. Thank you.
All right.
I guess I would say I know he feels like he's really in the fight for his life here. And
No, we're not on the record yet.
Okay.
No, we're still off the record. Yeah. All right. So y'all ready to proceed? All right. We're back on the record. Mr. Nicholson, this is what I want you to know. no matter what offenses people are alleged to have been committed in this court, it could be offenses that people think are the worst of the worst. I still see everybody as a human being. And when I look at them, many a times I see them when they first start school, like first grade. And I always wonder what made this one child turn left instead of going right. Some people have horrible childhoods